Shall I, Mita? Yes. Good evening, everyone, and welcome to today's discourse on a crucial topic that lies at the intersection of democracy, justice, and constitutional law, free speech, judicial independence, and the contempt dilemma. In a thriving democracy, free speech and judicial independence are foundational pillars. But what happens when these two principles collide? When does a person's right to express themselves cross the line into contempt of court? How do we balance the right to criticize with the need to protect the dignity and authority of our judicial system? Today, we will be exploring these complex issues with our esteemed speaker, Professor Dr. G.Mohan Gopal. Our discussions aim to dissect the nuances of this dilemma, its implications for our legal system, and the broader questions about the health of democracy itself. It is my absolute pleasure to invite Honorable Dr. Justice Kausar Edapagat, Justice, Judge, High Court of Kerala, and Executive Council member of the Indian Law Institute, Kerala State Unit, to deliver the introductory remarks.
Thank you, Anupama. Respected Professor G.Mohan Gopal, esteemed members of the legal fraternity, distinguished guests, students, and ladies and gentlemen. A very good evening to all of you. It's with great honor and privilege that I extend a warm welcome to each one of you to this much anticipated talk on the topic free speech, judicial independence, and the contempt dilemma, organized by Indian Law Institute of Kerala chapter. The intersection of free speech and judicial independence has always been a subject of profound debate. A free and independent judiciary ensures the protection of fundamental rights and prevents executive or legislative overreach. Judicial independence, however, does not mean immunity from public scrutiny. While courts have upheld the importance of judicial dignity, they have also recognized that criticism in good faith is essential for a democratic society. While democracy thrives on unrestricted expression, the judiciary as its cornerstone demands unquestionable integrity and respect. This creates an integrate contempt dilemma. The challenge lies in balancing accountability and criticism with respect for judicial authority. A lot of questions arise in this regard, like where does critical speech end and judicial obstruction begin? How do we balance accountability with dignity? Can fair criticism of judges be considered an attack on judicial independence? How do courts balance respect for the judiciary with accountability? These are pressing issues that demand deep legal and philosophical inquiry. We are privileged to have Professor G.Mohan Gopal, a distinguished legal scholar whose profound insight shaped constitutional and judicial discourses in India and abroad, to address these issues. A former director of National Judicial Academy and a thought leader in constitutional law, access to justice, and judicial reforms, Professor Gopal's scholarship has enriched both academic and policy-making circles. His ability to deconstruct complex legal dilemmas into meaningful discussions makes him the perfect guide for today's theme. In a time where judicial scrutiny and public discourse are evolving rapidly, especially in this digital age, this discussion holds immense relevance. We look forward to Professor Gopal's reflections on the legal, ethical, and constitutional dimensions of free speech, judicial independence, and contempt laws. Once again, I extend my heartful welcome to all of you. Let us prepare for an enlightening session that will challenge our perspectives and deepen our understandings. Thank you.
Thank you so much, sir. Professor Dr. G.Mohan Gopal is an individual whose career stands as a testament to a lifelong commitment to justice, equality, and the transformative power of law. From championing constitutional rights to shaping international legal frameworks, his influence has been profound, and his legacy will continue to inspire future generations of legal professionals and policymakers. His foundational education includes bachelor's degree in science from Kerala University, bachelor's degree in law and LLM from Delhi University, and doctorate in law from Harvard Law School. His career has also been distinguished by significant international legal experience as chief counsel at the legal department of the World Bank in Washington, D.C., and as counsel at the Office of the General Counsel for the Asian Development Bank. He played a key role in shaping policy and regulatory frameworks for international finance. Professor Mohan Gopal has also served as an adjunct professor at Georgetown University Law Center and as a lecturer in the law at the NUS Singapore. As a former member of the SEBI, UGC, and Oversight Committee on Reservations, Government of India, he influenced policy decisions that touched on key areas of finance, higher education, social justice. He also served on the Copyright Law Board of India and the Kerala State Planning Board. As a member of the National Judicial Academic Council, he has played an integral part in shaping judicial education and reform in India. From 2006 to 2011, he served as the director of the National Judicial Academy, Bhopal, one of the most pivotal institutions in India's legal landscape. Between 2000 and 2003, he held the esteemed position of the Vice Chancellor at NLSIU, Bangalore. Professor Mohan Gopal also founded and led the National Court Management Systems Committee, an initiative by the Supreme Court of India to improve court efficiency and reduce case backlog. As a member of the Law Commission of India, he contributed to the formulation of critical legal reforms that have had a lasting impact on the Indian society. In 2011, he was appointed as the eminent jurist member of the Judges Inquiry Committee, an important parliamentary body tasked with the investigation of allegation against a sitting judge. Beyond his professional legal career, he currently serves as the chairperson of the Sri Narayana Manava Dharma Trust. He was also the director of Rajiv Gandhi Institute for Contemporary Studies and the national president of the National Students Union of India. As a pro bono arguing counsel at the Supreme Court of India, Professor Mohan Gopal has steadfastly championed the rights of marginalized sections of the society. With the focus on constitutional law, he has argued landmark cases that addresses the issues of equality, social justice, and the protection of vulnerable communities. Now I request Professor Dr. Mohan Gopal to kindly address us. I would also like to inform our viewers that if you have any queries towards Professor Dr. Mohan Gopal, please put them in the comment box. We shall address them to our speaker after the session, holding an interactive session. Thank you. Sir, please.
Most respected Honorable Justice Kausar, distinguished office bearers of the Indian Law Institute, and other friends. First of all, thank you for those very kind and generous words of introduction. I think the stage has been set by us very nicely by Justice Kausar framing some very key issues. Where do you draw the line between free speech and interference in the judicial process? Where do you draw the line between judicial accountability and dignity, and accountability and respect? These are very, very complex and important questions. I think we can start safely from a position that we all agree completely, which was articulated perhaps in very strong terms by the Honorable Supreme Court 24 years ago in the year 2000 in Om Prakash Jaiswal versus D.K. Mittal, where the Supreme Court said availability of an independent judiciary and an atmosphere where judges may act independently. So they're making a distinction between an independent judiciary, and a very important integral part of which is an atmosphere where judges may act independently, which means they're not under stress, they're not under pressure, they are actually able to freely act independently and fearlessly. Independently and fearlessly. That means there is no stress on the judge, there is no influence on the judge, there is no worry in the mind, the human mind of the judge about any consequence that he has to battle and to assert his independence and his own judge and make his own judgment and decision. So an atmosphere where judges may act independently and fearlessly is the source of existence of a civilized society. Now, that's where I said it may have perhaps been very strongly stated, because I would argue that actually it is only in a civilized society that an independent judicial institution will exist, and judges will have an environment in which they may act independently and fearlessly. And that is a test or an indicator of the existence of a civilized society. But ultimately, it is the society which enables the existence of an independent judiciary and an atmosphere where judges may act independently and fearlessly. I think this statement of the Supreme Court may be our starting point, because we all accept that in a civilized society, there must be such an institution and the ability of those who manage it to act in this fearless and independent manner. We also recognize the fact that the legal system as we know it today, independent of the executive, independent of religion, is quite recent. It has emerged over the last 300 or 400 years. And as we know it today, is even more recent. And in our country, it is only 75 years old. It was created by the Constitution, a truly independent judiciary that fulfills these criteria. Now, why is this unusual and new? This is unusual and new because before this, the judicial function of deciding disputes and deciding whether human conduct is right or wrong, which we will all agree is perhaps the core and sole question that all of us are concerned with as lawyers and in the legal system and in the judicial system. Namely, we focus on the rightness and wrongness of human conduct. That issue has been an issue since time immemorial, since the dawn of human history. But the way in which that has been handled has significantly changed. Originally, this was an issue that was handled only by those who are in power and wielded power. So the monarchs used to decide whether human conduct was right or wrong, and if it was wrong, in their view, what would the consequences would be. But it is only perhaps in a very formal sense, nearly 250 years ago, with the emergence of the US Constitution in a written form, and before that in the unwritten Constitution of the United Kingdom, and perhaps a little bit of a couple of centuries before all this happened, gradually there emerged the idea that there should be a judiciary that is independent of the executive power and the legislative power. Why is that necessary? That's necessary because we need a constraint on behalf of the people on the action of the executive and the legislature. That's why we need an independent judiciary, because the independent judiciary acts on behalf of those who are outside the executive and the legislature to ensure that the legislature and the executive act within the bounds of law and the Constitution. If that was not the case, we don't need the judiciary. The executive itself, it has the stick, the danda, it has the power of force, it controls the money. Judiciary famously has neither the purse nor the sword. The purse and the sword are held by the executive and the legislature. In our country, they're both effectively the same. The leaders of those who control the legislature also control the political executive. So they have the purse and the sword with them. And we don't need, and why is there an independent judiciary independent of them? Because the people, we the people, want to ensure that those who have the sword and the power act in accordance with the Constitution. So my point is that this statement by the Supreme Court about the need of an independent judiciary and an atmosphere in which judges may act independently and fearlessly is really essential for the people of the country, for we the people. It is not essential for the powerful executive or the powerful judiciary. It was the task of the judges before the Constitution to, even in colonial times, to protect the powerful against the powerless. But upon independence and adoption of the Constitution, the role changed, and this is recorded by Justice D.A. Desai in his 117th report of the Law Commission, of which he was then the chairperson, on judicial education. It is really the founding document of legal education, judicial education in our country, where Justice Desai focused on the challenge for the Indian judiciary of transforming from, I'm quoting him, being an extension of the law and order machinery. So part of the powerful enforcing their law against the powerless. So from being an extension of the law and order machinery to becoming a sentinel on the qui vive, means a guardian on the alert. Qui vive means who goes there. So a guardian on the alert to protect the fundamental rights of people. And he said this is a very big transition that had to take place overnight upon independence. And it is for that reason that he said we must have judicial academies, and judicial academies were set up to bring about this very fundamental role in the functioning of the judiciary, or the responsibilities of the judiciary. Therefore, the first point I'd like to make is to remind all of us that today the judiciary exists in our interests, the interests of powerless people, to protect us, not to protect the powerful people. If that is the role of the judiciary, finally, we don't have to have all this expenditure to maintain a judiciary. We can just hand over power to the police. They are the ones who find the suspect. They can as well take care of deciding whether they're guilty or not and doing whatever they wish with them. So therefore, so it's an agreed point that we have to protect the judicial independence and the atmosphere in which judges may, as the Supreme Court said, an atmosphere in which judges may act independently and fearlessly. That's the first point. The second point is on the freedom of speech, as Justice Clauser said, and Madam said in a very nice introduction, the challenge of freedom of speech. Here, I would argue that here we understand that our Constituent Assembly and the Constitution had several competing and contending forces in the Constituent Assembly. And it was a real miracle wrought by Dr. B.R. Ambedkar that we came up with a unanimous constitution. But that did not mean that there were no contending forces. And some of the forces were on the side of democracy. Some of the forces were not on the side of democracy. And the battles that took place before the Constitution are still taking place today. And therefore, I see the Constitution personally in my work not as a document or simply as like in other countries, as an instrument that allocates power amongst different organs of government, but as a site of struggle. And that's why Dr. Ambedkar said in his last speech, now let's struggle within the Constitution. Let's not fight on the street outside the Constitution, because Dr. Ambedkar created the space inside the Constitution to have the struggle between very powerful social and economic forces over the future of India, post-colonialism, who in India is going to control this country. That's what the struggle is about. It's no longer a struggle about whether people from outside will control India or not, but within India, who will control the country. And that struggle should take place in the constitutional site rather than in on the streets. This is what Dr. Ambedkar wanted, and he has provided in the judiciary also, in the nature of the judiciary, a very important instrument through which this struggle can be waged in a peaceful, lawful, constitutional manner rather than on the street. But here what we notice are two things. One is on freedom of speech. We know I'm not trying to not to say things which everyone knows, but we know that 19(1)(a) gives us freedom of speech and expression. And we know that that 19(2) sets reasonable restrictions on freedom of speech and expression. Now, what I find significant is that the language of 19(1)(a) is not that subject to 19(2), there will be freedom of speech and expression. The language simply says that all citizens shall have freedom of speech and expression. There is, in 19.1a itself does not contain any suggestion that 19.1a is subject to anything else. And I think that's significant, because there are a number of other provisions where the grant of the right itself is made subject to the constraints are set out in the grant itself. So I'm just trying to pull out 19 in my copy of the online copy of the Constitution, so we can just read it. I had the privilege of seeing many times Justice Krishna Iyer. He had a little Constitution in his pocket, and whenever he cited the Constitution, he would pull it out and read it as if he'd never seen it before, as he was a first-year law student. He'll say, let's read it. And then he will read it. And so I think that was he must have read it millions of times, but every time he referred to it, he would want to read it. So Article 19 says, 1, all citizens shall have the right, A, to freedom of speech and expression. That's all. Now that itself is significant. And then separately, Article 19.2 says, nothing in subclause A of subclause 1 shall affect the operation of any existing law. So you can see there are two separate sort of provisions of constitutional law. One is the grant of the recognition of free speech. The second is a set of laws being enacted by Parliament imposing reasonable restrictions on the exercise of the right, not on the right, on the exercise of the right conferred by the said subclause in the interest of, and then it makes a list of 10 items. So I think this wording is significant. 19.2 does not really restrict the right. It restricts the exercise of that right. That shows how sacred this right is, the formulation, because we know that it comes also from the preamble, which declares that we the people have resolved to secure to ourselves liberty of thought, expression, belief, faith, and worship, all of which are interrelated and are very much reflected in all the provisions in Article 19. Now, if you look at the reasonable restrictions, there are 10 reasonable restrictions. Okay? I'm not listing them, but there are 10 reasonable restrictions. In contrast to the fact that 19.1b has only 3 restrictions, 19.1c has 4 restrictions, 19.1d and e together in Article 19.5 have only 2 restrictions, and 19.1g, which is restricted by 19.6, has only 2 restrictions. So as against 2 or 3 restrictions, 19.2 imposes 10 restrictions on 19.1a. That it can be restricted in the interests of the sovereignty of India, integrity of India, security of the state, friendly relations with foreign states, public order, decency, morality, contempt of court, defamation, and incitement to an offense. So contempt of court is one of them, which is why I refer to that. Here, this is another topic, but since it is mentioned here as freedom of speech, I want to make a point that many of the forces in the Constituent Assembly, and many of those forces are still dominant in our country, are very uncomfortable with freedom of speech and expression, which is why there is almost 5 times the number of reasonable restrictions that may be made through law for freedom of speech. There's some fear of these people of freedom of speech and expression, and it must have been quite a miracle for Dr. Ambedkar to get freedom of speech and expression expressed in the form that he did, in an untrammeled fashion in 19.1a, with the 19.2 being worded in many. I sometimes feel many of these subtleties were probably lost to everyone in the room except Dr. Ambedkar, who very deeply understood every full stop and every comma of what he was talking about. Now, having established that judicial independence is very important for us, that freedom of speech is equally important for us, I will make a third very simple point, and again, that's worth another huge discussion, because I find that courts always look at the challenge as balancing these rights. Now, that's a notion that I find predominantly only in Indian jurisprudence. Very few other courts of democracies talk of balancing rights, right? Actually, the job of the judge and the judicial system, not the judge, the court, is to protect both these rights. Now, we may not be able to protect both rights always. So we have to find the best way of protecting it, but there is no legitimacy for the state to balance rights. Balancing actually becomes almost a legislative constituent act. Whereas implementing in a harmonious way, it's like a doctor has to save a life of one person, may end up having to make a choice like we saw in COVID. Do I save the life of a young person because I have only one cylinder of oxygen, or do I save the life of an old man like me? And he may say, he may have contempt, as the topic is contempt. The word means not recognizing the value of something and not giving it the consideration it deserves. So he may look at an old man like me and say, this guy's life has no value. I'll save a young person's life. So that's not an act of balancing. It's an act of deciding what to protect and what not to protect, recognizing. Why is that important? Because you must recognize that you're not protecting something when you do something. Balancing gives you the wrong feeling that somehow you're protecting both, but you're not protecting something when you balance. So we have freedom of speech, we have judicial independence, and the atmosphere of in which a judge should see. It's an intellectual function, judging. The judge's mind should be completely free of any stress, and judge should be able to decide fearlessly and independently. So we need that. We need a freedom of speech. And how do we protect both? Is it possible to protect both? That's really the question, I think, that we can reflect on today. And what I would argue is, because that time is always limited, and so within that time, I thought what I would do is, rather than go over what is well known, I'll frame a question. And that question is, what are the consequences? What are the consequences of our restricting through using contempt law? Restricting, what does contempt law do basically? Right now, to put it in a nutshell, contempt law basically says you cannot criticize a judge with reference to the judicial proceeding or a judgment. You cannot attribute motives, you cannot attribute fault, you cannot criticize a judge. So there's a complete blanket, virtually blanket immunity around a judge. Okay. Now, I agree that protection is necessary because the judge must be protected. That's why I strongly emphasize that. But that's how we are applying it. The second thing is that two other factors. The current contempt law says you have to obey the court. No question. There, I don't think there's any controversy. A court, when it gives an order, you can either challenge it. If there is no challenge, you have to obey. There's no two choices about it. And the third thing is you cannot interfere with the judicial process, the administration of justice. That's also unexceptionable. So let's focus on the question of what are the consequences of completely prohibiting criticism of the judge and permitting criticism of judgments, not the judge, but without reference to the judge. So there you can say, like the Supreme Court has said, ADM Jabalpur was wrong, without criticizing any of the judges. In fact, we have another case where I think it was Times of India that published something about one of the ADM Jabalpur judges, and there was a contempt proceeding on that. The majority said there was no contempt. There was a dissent saying that there was contempt. So you can criticize the judgment, but not so. Supreme Court itself and high courts themselves criticize judgments of the district judiciary or of each other, the same size bench or smaller benches, and we can do that for good reason, where the law is wrong, or even if we agree or disagree. And frankly, there's no concern about that. I don't think there's any real concern that anyone is restricting our ability to do that. But sometimes it is not enough to understand what is really going on. And so I'm now faced with such a situation where I'm dealing with judgments in our country, there's no question of the fact that they are well-reasoned, The judges are absolutely well-intentioned. They're very competent. They're brilliant judges. They're not acting in accordance with any, post-retirement or pre-retirement or nothing in mind. They're acting fearlessly and independently out of their own accord, right? But we still have difficulty with the judgments. Why do we have difficulty with the judgments? Because what they're violating is not the law. What I believe they're violating in many of these cases are unwritten conventions on judicial interpretation. So, for example, the convention that the law must be drawn only from statutes or the Constitution or judicial precedent. But we find an increasing tendency where judges are drawing from religious sources in their judgment. There's nothing in law that says you cannot do it. And that's not new. We've had judges who have written couplets in their judgments, poems in their judgment. They've cited religion. It is an unwritten convention, professional convention, that actually a judgment has to be based only on the Constitution, the statute, or binding judicial precedent. And now, how does society become part of since I said at the beginning that the courts are concerned only with normative issues, and ultimately norms come from society. How do norms come from society into the legal system, the Constitution or the law? Theoretically, I argue that the part of society from where norms come is what in social sciences they call axiology. Axios means value. Axiology is a study of how people decide what is valuable and what's not valuable. So in some European countries, saying that the Holocaust did not happen is a crime. So that's a restriction on free speech. You simply cannot say that the Holocaust did not happen. It's just too much. So in their value system, in society, there was in their axiology, somewhere in the axiology, there emerged the feeling that this is, given that 65 lakhs of people were brutally murdered in a systematic manner, factory style, only because they had a certain religious faith. To deny that this happened was something that is unacceptable to people. So they made it into a crime. But how did they do that? And in our country, we have multiple axiologies, multiple sets of values, community, and including religious and non-religious communities. How does a norm come into the legal system? In my view, now think of a border crossing going from one country to the other. There is a legal border crossing of norms into the legal system only through the Constitution. So to bring a norm into the legal system, you have to first bring it into the Constitution, which is why the Constitution has a supermajority. So you take a norm, you feel this must be a Grundnorm. Constitution is called a Grundnorm. It must be a Grundnorm. Bring it into the Constitution through a democratic legislative process. Once it is in the Constitution, then it can either be a part of the basic structure or it need not be part of the basic structure. If it's not part of the basic structure, it can be altered. Justice Kapadia, in one of his judgments, very nicely says how you differentiate between how you identify something as a basic structure, and he sets a test that something must be accepted in judgments as part of constitutional law before it is treated as basic structure. So there is a two-tier process to become basic structure. First, from society through parliamentary amendment, it comes into the Constitution, becomes part of the Constitution. Then it gets recognized as a constitutional principle by judgments, and then it is recognized as a basic structure. These are all safeguards. But when you bypass this process and in a judgment, a bench or a court or a bench of a court directly dips into society, into axiology, bypassing the Constitution, and puts it in the judgment, and then it becomes part of the law of the land. Now, so far I've been saying this, I've not had, I've been saying it with great respect and expressing concern about, I'm saying this to protect the judicial system. Because the public is looking at this process and they are losing faith in the judicial system. So one of the consequences of protecting, the inquiry into what judges are doing beyond the traditional Lakshman Rekha of the law is wrong or the law is wrongly cited or something like that. But looking at these unwritten conventions, when we do that, we have to explain to people that, look, the problem is not with the Constitution. The problem is not with judicial system. The problem is not with judicial independence. These are all necessary for our well-being. The problem is some particular judges are doing something that they should not be doing. And when you say you cannot criticize the judges, the blame then gets shifted to the Constitution and the judicial system. Whereas when I say, so it's like there's a surgery. The hospital is excellent, the science is excellent, everything is followed, but the surgeon messes up. If you cannot question the surgeon for having messed up, not followed what he's supposed to do, written or unwritten, then people will start blaming the hospital or the other medical science. And that is, so if you want to protect the institution, the hospital, the medical system, and medical science, you've got to point out, no, there's nothing wrong with the medical system or medical science. There's something wrong with the way this doctor performed the operation. And then we can find out where did the doctor go? When a plane crashes, we look at what did the pilot do? We can't say, don't look at what the pilot did. We need fearless pilots, independent pilots, sure. But we have to look at what the pilot did. And we may find that the pilot did nothing wrong. Then we look at the plane and its engineering and the air traffic control and the systems. So the problem I'm saying is that the consequence of shielding the judges from being questioned for their actual decisions is that the public is losing confidence in the judicial system and the Constitution. Whereas a large number of judges, I would say, I'm not trying to distinguish between good judges and bad judges. Let's say large number of judgments are very much following the written, established conventions of judicial interpretation, drawing their norms from within the Constitution, applying the law, using unwritten, uncodified rules of judicial interpretation, golden rule, justem generis, all these things. They're using all that, and they're coming to good recent judgment. So fundamentally, I believe that the Constitution and the system we have under the Constitution is sound and stable. But unless we find a way to clarify the way that and so I do believe that we do need a power for the court, contempt power for the court is necessary, where the court is disobeyed or where judicial processes are interfered with, and where there for malafide reasons to weaken the system, people try to basically attack the credibility, systematically malafide attack the system. We do need the powers of contempt of court. Contempt, as I said, simply means not having any respect for the institution, considering it worthless. That is dangerous. So we cannot allow that to happen. But it must be well reasoned. It must be well reasoned. And it must be substantive, and it must be convincing. Now, this is where the issue of accountability comes in, because I've had the privilege of being a member of one of only 4 or 5 judges inquiry committees that have been set up to hold judges, High Court and Supreme Court judges accountable. So far, I was involved with the matter relating to a Chief Justice of a High Court. And I personally believe that the Judges Inquiry Act, except that it's very difficult to trigger, but sets out actually a good process. There is a fact-finding where there's a sitting Supreme Court judge chairing, there's a sitting Chief Justice of a High Court and a jurist. And it's a very serious process. I've had personal experience of it. It's just that it can't be triggered easily, and there are so huge gaps, and it's very political. The triggering is very political. So we need to strengthen the ability to raise these questions in an appropriate way. I've now that I'm pro bono, without taking any fees or costs, arguing some cases for behalf of marginalized sections on constitutional law. I won't mention obviously any names or anything, but I know at least 3 cases that I'm involved in where the system has not failed, but maybe it's my failure. I have failed it is my failure, not maybe. I failed to somehow persuade the judges to see the real issue, which is a constitutional law issue, and they see it more as, and I failed to see that. I succeeded for some judges, but not for the others. So it could be a failure. When I do that, then I should be able to say, okay, my fault, but in these cases, the judges did not really, their judgments are unexceptionable. They followed the law. But they did not, in a formal sense, they followed the law. But as I said earlier, they drew upon, while following the law, they violated what I believe are unwritten conventions on judicial interpretation, which are not a base, which I cannot. It's not a basis on the basis of which I cannot even go in appeal. I have gone in appeal, but those appeals are in 1 or 2 cases, but they have to be based, as you know, on error on the face of the record or violation of some statute or law. So I won't go into those cases, but I have personal experience of this system. Now, what's the solution? What's the way forward? I think I'm very happy to be speaking to the ILI. I've been a member for some years of the ILI Executive Council and Academic Council and so on. Not now, but I have been. And I have a lot of regard for the institution, and I'm very happy to see such a vibrant state branch of the Indian Law Institute. I am not aware of any other state which is so vibrant, and I'd like to compliment the members and the leadership of this Indian Law Institute group for that purpose. But I'm also very happy to be able to talk to lawyers at the Kerala High Court, because I think one of the finest judges who delivered the judgment, and the judgment is really the judgment of Justice K.K. Matthew when he dissented in the contempt case against E.M.S. Namboodiripad in 1968. It's a wonderful dissent. It's the range of law, and he goes through freedom of expression and what it is, and freedom of speech. And he looks at US law and Indian law, and then he and I have no time to discuss this in depth, but I would certainly recommend to everyone on this issue of contempt of court, this is the judgment to read, and I wish that his judgment would become the norm. And I think the way forward is really to institutionalize the thinking of or the dicta of Justice Matthew in his dissenting judgment. He says, I just quote a couple of lines for lack of time. Justice Matthew says, the power to punish, I'm quoting the Kerala High Court judgment. There is a Supreme Court judgment that, as you know, upheld the contempt conviction against EMS, and there was no dissent there. So Justice Matthews is the only dissent. Justice Matthew writes, the power to punish for contempt by scandalizing a court is understandable when seen through the perspective of its age of inception, an age of alleged divinely ordained monarchies, ruled by a king totally invested with all sovereign legal powers and accountable only to God. Under any circumstances, resistance to the king was a sin which would bring damnation. Right? And then he goes on to discuss how this is not acceptable in a democratic country. And he says, as I've said, and he looks at the accusation and he says, the respondent is a member of a political party which professes a particular philosophy of state. And as a member of the party, he believes that in the present setup, the system of administration of justice will only serve the ends of capitalism. The question is whether the respondent in good faith believes in this philosophy and has a right to express it. Of his sincerity and good faith, I have no reason to doubt. The petitioner himself says that the respondent is a person of, the petitioner, Mr. Nambiar, says that the respondent, Mr. Nambudripad, is a person of strong conviction and he has fidelity to his ideologies, and I respect him for these qualities. There is no allegation that he is motivated by malice to any judge. In the nature of the generality of the allegations, malice is out of the question. He has not attributed any improper motive to any judge. On a balancing of rival interests implicit in the test of reasonableness formulated by Patanjali Shastri CJ, it will be found that the interest of society in self-government by free discussion is much more important. This is what Justice K.K. Matthews says, that the interest of society in self-government, that is by the people, by free discussion is much more important than the maintenance by coercive process of artificial and hypocritical respect for courts and judges. Immanuel Kant said in his Metaphysics of Morals that love is an internal feeling that cannot be commanded. So also is respect, says Justice Matthew. And then he says, the test should not be, the test for contempt should not be whether the words have a tendency to create disaffection towards the judiciary, but whether they have a tendency to bring about the substantive evil, namely interference with the course of justice. So he's constraining the scope and ambit of contempt of power to substantive interference with the course of justice, which I think is absolutely legitimate. That should not be tolerated. It will go against the rule of law. But it is in this kind of background that we do not codify, and we must not codify the unwritten conventions of judicial interpretation, which are all intended to uphold the Constitution and the rule of law, not to diminish it. So the question that I want to end with is to ask, what happens, what should we do when contempt of court powers prevents us from challenging the decisions or actions of particular judges, which are actually then being blamed on the judicial system or as a failure of the judicial system or the Constitution. And by identifying the failure of the judge in a particular case to follow for good reason, substantively, bona fide, to not attributing any malefides, to follow certain conventions, unwritten conventions of judicial interpretation, for example, reaching beyond the Constitution to religious values as a Grundnorms, right? Or, for example, we are saying that judges should not be attacked or criticized. I was very shocked to see, as was Justice Dhulia and Justice Nagaratna, language by the former Chief Justice of India criticizing Justice Krishna Iyer, near judgment of the Supreme Court, saying that he was imposing his personal ideology, right? Or in putting forward an ideology that is part of the Constitution. And now, is that likely to actually lower the respect of people in the judicial system? Yes, but can I say that should I be allowed to say that, saying, look, this is really, what Justice Krishna Iyer did was actually to uphold the judicial system and the Constitution, and the criticism should be analyzed objectively and said, look, this criticism is ill-founded and also goes outside the permitted bounds of unwritten conventions on judicial interpretation, of making personal comments about a judge sort of imposing his personal ideology, which he was not doing. He was imposing the ideology, not imposing, he was honoring the ideology of the Constitution. So what do we do in such cases when, as a result of the application of the contempt of court law, the harm is done to the judicial system as a whole, to the good work of the vast majority of judges, and the Constitution, and their credibility is affected? And I think that's an immediate problem which we need to assess. And one way to solve that problem is to apply the K.K. Matthew doctrine, that, as I said, the test, and I'm quoting Justice K.K. Matthew to conclude my remarks, and we can have a discussion. The test should not be whether the words have a tendency to create disaffection towards the judiciary, but whether they have a tendency to bring about the substantive evil, namely the interference with the course of justice. And that will then provide the space to protect the judicial system and the Constitution and allow us to move forward. Let me stop here. I think I've spoken for about, I think, about 45 minutes or so. So I'll stop here, and I'll be very happy to take any questions.
Yes, sir. We'll check the comment box and get back to you with respect to the questions.
Sure.
Sir, I have a question here.
Sure.
The question goes as this. Do you opine that all the restrictions in 19 clause 2 would apply?
See, as we know that, as I discussed, the language of 19 clause 2 is, as we read it, very carefully crafted. It basically says that nothing shall affect. Let's read it again. It says nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law, insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interests of, and then there are these 10 constraints. Now, of this, our topic today refers only to contempt of court. And defamation is, in my view, different from contempt of court. They're totally defamation in other countries. If a judge is entitled to protect his or her reputation from defamation, and they would have resort to normal courts to sue for defamation if someone should defame them. So that's different. So the other 9 are not really immediately, they're all interrelated, but not relevant to our discussion today. But the larger point I was making was that it's clear that a lot of people were most uncomfortable of all the 19.1, 6 rights under 19.1, 6 freedoms under 19.1. The freedom that they seemed to have a lot of concern about was speech and expression. And that is because we were not yet in a democracy when the Constitution established the democracy, and free speech and equality were 2 incredibly dangerous ideas for the monarchies and oligarchies that ruled India until 1950. And as Ambedkar said, even now we have gone from being a monarchy to being an oligarchy. So the oligarchy means power in the hands of a few people. That's what oligarchy is. Oligos means few people, archy means ruled. power is controlled by a few people. And in that kind of system also, they have great fear of speech. So basically, our interpretation of the power of contempt, which is extremely broad, extremely vague, and constantly putting a pall of fear over everyone to talk about anything. And because we saw how in one case, there was a tweet, and that went from tweet to conviction in 2 weeks or so, roughly 2 weeks. Right. And when even the Attorney General at that time didn't seem fully convinced that it was something that for which there should be a conviction. So we can see how this power is exercised. So independence of judiciary is utterly essential. But as Justice Kausar himself said at the beginning, it is very important to ensure that independence is used to uphold the Constitution and its values. It's only an instrument. It's not deontological. It's not an end in itself. It's not. Then it becomes arbitrary power, and that's not the intention. So I think the contempt of court. What is contempt of court is largely now through judicial interpretation. Also because the judiciary has said in various judgments that the power of Supreme Court and High Court under Articles 129 and 215 of the Constitution come from the Constitution, so cannot be constrained by the Contempt of Courts Act of 1971. They can set out procedures, they can set out some details of how it's implemented, but the power is overriding, and it's very personal, and it's summary in nature. So all this together has led to a very broad and expansive interpretation of the Constitution, which is what Justice Matthew was dissenting against in 1968. Right, that is like 1978 is like 56 or so years ago, right? If my arithmetic is correct, 1968 to 70, 32 plus 25 is 57 years ago. And
46 years.
yeah, so over half a century ago. Sorry?
1970 is 46.
No,
1978 is 46. 46 years, sir. 46 years. 46
Sorry.
years. Less than 50.
Yeah. 46 years ago. Okay. 68. I'm saying 68, ma'am. 68.
68 is 57.
57.
Yeah, that's why I said 57. It's the K.K. Matthews judgment. K.K. Matthews judgment is 1968. Is 1968. So that's 57 years ago, not 78. The Supreme Court judgment on EMS was 1970. The High Court judgment, Kerala High Court judgment was 68. So that was 50. And he was then a judge of the Kerala High Court. That was 57 years ago. And so that still gives us a vision on how to provide some guardrails in which judicial discretion on contempt of power needs to be more predictable, so that people can adjust their behavior to make sure it's within the law. Right? And only the judiciary can provide that kind of predictable framework with which a legitimate use can be made of a legitimate need to ensure that court orders are obeyed, that no one disrupts the processes of the court. Right? And scandalizing the court, of course, Justice Matthew quotes in his judgment, is something that the US never brought in, was been given up in the UK, and is obsolete. And that's why Justice Matthew says scandalizing the court is really not relevant anymore. Only these two objectives are there. And he actually quotes Justice, refers to, I think Lord Atkin refers to Ambert versus AG for Trinidad, UK House of Lords judgment, in which is a very famous quote, we all know this, which says that justice is not a cloistered virtue. She must be allowed to suffer the scrutiny and respectful, even though outspoken comments of ordinary, they said men, it should be people, of ordinary people. So justice should be allowed to suffer the scrutiny and respectful, even though outspoken comments of ordinary men. Right? These are wise words so that the hit is taken not by the system or the constitution. And so I think this is the main question I want to pose. What kind of guardrails can be put by the judiciary over the bounds of its own power on contempt of court? I think the time has come for that to be provided so that people can work in a predictable environment. And we don't have such a situation that a tweet goes from a tweet to a conviction in 2 weeks. There should be some predictability. And the action should be such that actually there should be some consensus amongst the judges, senior members of the bar. You shouldn't have a contempt proceeding where the Attorney General is not convinced. So there should be some consensus, because it is about protecting the system, not about protecting the judge. It's contempt of court, not contempt of judge. The reasonable restriction in the Constitution says contempt of court, not contempt of judge. So when the Attorney General is not convinced that there is contempt of court, the judge may feel that he's been hurt and there's contempt towards him. Is that enough? Should we not raise it to the level of contempt of the institution of which we are all a part? I mean, and how should that be done? I mean, this is really something that perhaps should be raised before the Supreme Court, and some guidelines should be provided on contempt of court so that the contempt power actually becomes more effective. And courts are genuinely more protected. We also find, on the other hand, things that most everyone thinks is contempt of court, and there's no action. So judges take it with their broad shoulders and say, okay, fine, we'll maybe good judgment. So there is a lot of unpredictability, which is not good for the legal system.
Sir, I have another question here, which I think is like the other side of the coin. The question goes as such: judges are now expressing public opinion in public meetings and also religious remarks to criticism on such matters. Should contempt jurisdiction be invoked, especially if the judges are contextually incorrect?
The answer comes from Justice Matthew's doctrine and test. I think, very simple. If there's no role for contempt for that. There is a question whether that judge is being true to his oath or not. Right? And that's a separate issue, and some proceedings are being initiated in that respect. And I think there should be more, and the Supreme Court called a judge in one such case and talked to him. But Justice Matthew gives us a very clear test. If such remarks affect the administration of justice, yes, it should be contempt. But if not, so that's what Justice Matthew says in this case also. What are the consequences of EMS saying this? Where is the interference with the administration of justice? He's expressing a view, which is the view of his party. He's not scandalizing any judge. He's not scandalizing the system. This is his genuine opinion. And he's expressing it, right? If there's a consequence, or there is a likely consequence, now that goes back to the test. See, the other problem in our country is, unlike in the US, for example, there is no general standard on freedom, when freedom of speech can be constrained. We are going, like for contempt, we have one standard. For sedition, we have another standard. But in the US, they've evolved a general standard, which was laid out in a number of cases. The latest is Brandenburg versus Ohio, where the broad test is that there should be an imminent threat of lawless action. If the speech immediately will result in lawless action, that speech should be stopped because it will affect the freedom of others. And so there's a general test. But Justice Matthew in detail discusses in 68. The Brandenburg, I think, came around that period in the 60s. So it may or may not have been. I don't think he refers to Brandenburg. And but he refers to New York Times versus Sullivan, which he discusses at length. So he's suggesting that we should also have, he's not saying it explicitly, but his discussion suggests that we should adopt a general standard on freedom of speech, right, which will be applied in all situations, including for contempt of court. And that should, and for contempt of court, of course, it's a unique situation. So the Matthew Doctrine, as I call it, says that it should be limited to where there is actually, an interference with the administration of justice, and not for criticizing the judiciary. There's also a famous book called The Great Dissent about how Justice Oliver Wendell Holmes changed his position from being anti-free speech to being pro-free speech. And he wrote a dissent protecting free speech, and how that evolved. I'm not getting into the details of that, by conversations between him and then some academics and some other judges, Justice Learned Hand, and so they all talked. And the rationale that Oliver Wendell Holmes gives for free speech is a very important rationale. He says those of us who have the power to decide matters of great destiny for our country at very high levels, like Justice Kausar and so on, sitting at the highest levels in our country, of the entire country, they have huge responsibility, and their decisions will affect the future of the country for years to come, even small decisions. So Justice Holmes, who occupied a similar position like Justice Kausar, he said, look, my concern is I want to know if I'm right or wrong, if my decision is right or wrong. And he said, the only way I can know if my decision is right or wrong is to let everyone attack that decision. Then I can see whether there is any value in this attack. And if I find some value in the attack, I can correct myself. But if I give a decision and there's silence around me, I will not know what this decision will do for my country, to my country. So he said, therefore, except in very limited cases, like where there is a threat of imminent violence according to the first test and imminent lawlessness according to the second test, there, because of the immediate consequences, we can say, don't say that. Like the famous example is, if you shout fire in a crowded theater, that's not free speech, because there may be a stampede and people may die. So you don't have the freedom to exercise your freedom to take away other people's rights and freedoms. That's the only line. But the rationale that he put forward was a very pragmatic rationale, that I need to know if my decision is right or not. And only if I provide maximum space for my decisions to be questioned, will I know if there is a valid criticism out there which actually convinces me that I was wrong. That is what Justice Matthew is doing here. He's saying, he's going further than criticize the judge. He says, criticize the judiciary, no problem. But don't make speech that obstructs the administration of justice, because the justice system must function well. Otherwise, we are all in trouble. So Justice Matthew is also opening up the space for the judiciary and the judges to be criticized, including himself. Remember, when he's writing this judgment, it is early in his career. He's puisne judge of the Kerala High Court. He's opening up the space for him to be criticized. This is not like Mohan Gopal saying, let's open it up for judges to be criticized. It's easy to say. He's a sitting judge at the early part of his career saying, criticize me.
So we
Don't
have
worry.
another question. Sorry?
Yeah. Justice Matthew is telling us, criticize me, don't worry about it.
So this is our last question.
Yes.
Given that contempt laws originated in colonial era framework, are they relevant in modern India, or should the law be curtailed to punishing for disobedience of judicial orders, not for criticizing the court?
Again,
Sir,
the
can
answer
I
is
ask can I ask a
yes.
follow-up question with that? Maybe you can take them
Sure,
together.
sure.
A lot
Sure.
of the origin countries, insofar as the Canadian experience, the English experience, and the American experience are concerned, have now done away with criminal contempt. But would that ever be a good idea for a country like India, which is not only highly litigious, but is also extremely reactive and very, very persuaded by explosive speech?
Yes.
Would it ever be a good idea for India to take away? I understand the limitations that criminal contempt would come with. Civil contempt, of course, nobody has any objection to, but would it ever be a good idea for India?
No, I think that's, with great respect, I think, we have, that is contempt of the people. To say that these people they're not, mature enough or reasoned enough to be able to exercise criticism in the right way. I find that there's no merit in that. I mean, people are people, and we must respect people for their mere humanity. And not be, I'm not saying you're doing that, but we must say, look, you're a citizen of this country. And this constitution is providing us equal citizenship. The fight is today for equal citizenship. Because till 1950, we had no equal citizenship in our history. And the ruling elites of this country are struggling with the idea of equal citizenship. If you belong to X religion, you're not an equal citizen. If you belong to X caste, you're not an equal citizen. So we have to say, such as it is, let people have the freedom, let them exercise it. Oliver Wendell Holmes once said, after his conversion to this democratic idea, he had fought in the Civil War, almost died, but later he realized the value of democracy. And he once said, if the people of the United States tell me that they want to go to hell, I will help them to do that. That's my job as a judge in a democracy. Not to say, no, let me tell you, I'm a wise guy. You should not go to hell. But when you have masses of people, I believe that today we are a democracy because the common people of this country are inherently democratic. Our freedom struggle was fought by common people in this country. And they won us democracy. They will safeguard democracy. Now, if I don't believe that we should strip the courts of their rights to, as Justice Matthew said, to take necessary steps to prevent disobedience to orders of the court or interference with the administration of justice. And whether it's called contempt, that's why you call it contempt of court. That is contempt of court, literally saying that, look, I have no respect or value for what the court does. Right? The question is contempt of judges, contempt of court? Right? And there is a gray area where you can express contempt of a court through expressing contempt of a judge. There is a sort of a segue or a gray area there. But we also have we have in the BNS, in the old IPC section 228, but in BNS we have 262 and 221 and 223, all of which say that you cannot disobey public officials, right? So there is a broad cover that covers not only the judiciary, but so we have very strong, sort of quite draconian provisions to ensure that people obey the law. Should the court have the power to take summary action, not prosecute under 220, the current BNS 221, 223, or 267, our old 228, I think, is now 267. That's why I have to keep referring because there are new numbers. But I think the court should have the ability to act immediately and take necessary steps. So I think those powers should be kept. The question is what Justice Matthew says. Should criticism of the judiciary, when it does not affect the administration of justice, that is what most democracies have done away with. Most democracies have done away with. Are we ready for that? Yes, I think we're ready for that. Is our elite ready for that? Probably not. Are common people ready for that? Yes, they are more than ready. They brought us democracy. They will handle it very well. And there are judges who will ensure that it works well. There are still judges, many judges like K.K. Matthew. I'm sure there are many judges amongst, particularly our Kerala judges, including his very distinguished son, who've been deeply influenced by Justice K.K. Matthew and Justice Krishna Iyer and others, and are following in their very wonderful traditions. So I think my bottom line is, let's go back and reread Justice K.K. Matthew's dissent closely, and let's try to understand it. And maybe that gives us a way forward to bring some clarity into using this important power. I started out by saying we need to protect judicial independence. We need to have judicial accountability. That's a larger issue and a more complex issue. But as part of that, we need to ensure that judges have the atmosphere in which they can decide fearlessly and independently. That's essential. And is our current contempt law doing that? I think to some extent it is, because there's a blanket kind of silencing of comments on the judiciary. So maybe it is doing that by and large. And there aren't too many controversies around that. There is still a lot of controversy around civil contempt, but not about criminal contempt. So by and large, it's doing it. But does that come at a price, is what I'm asking, especially today. And that price is that the people are starting to lose faith, exactly the opposite of what contempt of court law is intended to do. People, as a result of the silence about what judges are doing, they seem to be, in many of my interactions, questioning the Constitution and questioning the judicial system, and saying it's a failure of the Constitution and failure of the judicial system. So now the contempt law has become such that while it is protecting the independence of the judiciary, it is actually having an unintended consequence of people sort of needlessly blaming the constitutional framework and the overall judicial system for instances where there may be failures on the part of judges, and there is no effective mechanism of judicial accountability where those issues can be raised. And to some extent, like following the unwritten codes of the judicial interpretation, there can be no mechanism. No one can tell a judge no one can tell a law teacher how to teach ADM Jabalpur, say this or say that. It's an independent professional function. Similarly, no one can and should tell a judge how to interpret law or the facts. And these unwritten conventions have evolved from the judges themselves through their own practice. So they have to have fidelity to what they themselves have created, not imposed on them. So when such things happen, all we can do is to point out, as I did, and I'm using the word theocratic judging to describe instances where the Grundnorm comes from religion and not from the Constitution, as a method of judging, not theocratic judges, but theocratic judging as a method of judging, which is new, which is coming from judges. And so they need to reflect on that. And so I think Justice Matthews, the Matthew Doctrine, gives us a much clearer way of moving forward and ensuring that there is feedback to judges about what they have the sovereign right to decide. No one can interfere with that, how they interpret the law and how they interpret the facts. But they need to get feedback on that, and they will consider that feedback, and they will make the appropriate judgment about how to go forward. But the contempt law must provide space for that, is what I'm arguing. And Justice Matthews' doctrine creates that space. But it must be exercised responsibly, without malefides. It should not be misused. And for all that, we can go to the court and say, look, this is malafide, this is ill-intentioned, there is no basis for any of this, and then it goes into real contempt, because if you do that malafide, you're actually obstructing the judicial system. And so it immediately falls straight into contempt of court, not because I spoke, but I spoke with malice. I spoke with untruth, or I spoke with no substance. Then why am I saying this? I'm saying this not to defend the judicial system or the Constitution, but to obstruct the judicial system. And that becomes classic contempt, and you must act against me for that, if I do that.
Thank you, sir. It was a pleasure having you here with us for this session, sir. And you have shown freedom, free speech, judicial independence, and contempt dilemma in a different light. Thank you so much, sir. Now I invite Advocate Pooja Menon to deliver the concluding remarks.
Professor Gopal, Justice Kauza, Unisa, Parvati ma'am, other dignitaries and seniors joining us online, my colleagues, ladies and gentlemen. I have always sympathized the soul that is chosen to deliver concluding remarks, especially in the wake of just pure academic brilliant thought, because any spare word seems like it is reductive. I cannot say anything that that will either add or improve what the professor has already said, but this daunting task is my lot and privilege today, and I shall now discharge it. Speaking as a free speech maximalist and perhaps not a free speech absolutist, this importance and width of free speech versus in open societies versus reasonable restrictions placed on it by virtue of Article 19, on the face of it might perhaps seem like it is a balancing act. But like the professor has already shed light, on closer inspection, there appears to be very deep underlying currents which have legal and jurisprudential implications. By that, what I mean is, I believe it was in the summer of 2021 when I had the opportunity to read the professor's article entitled Contempt Unbound on his blog and website, freshly in the wake of the Advocate Prashant Bhushan's contempt matter in the Honorable Supreme Court. But in the article, the professor makes three extremely compelling arguments. Number one, that the judgment itself is per incuriam, for the reason that the Supreme Court lacks, and this is what I mean by the legal and jurisprudential, moving beyond the simplistic argument of whether it's a free speech versus reasonable restriction issue. There is also the legal issue, which is this: the Supreme Court lacks powers over contumacious speech when it is not exercising powers under the Contempt of Courts Act. That under Article 19(2), any restrictions on speech and expression on the grounds of criminal contempt can be imposed only under the Contempt of Courts Act. The professor argues that when the Supreme Court is not acting under the Contempt of Courts Act, it has no such power to restrict contumacious speech and expression. The Supreme Court may punish other acts of contempt under its constitutional powers of contempt, but not on free speech and expression. I hope I've got that correctly, Professor.
Yes, absolutely. Better than the way I wrote it.
Secondly, the professor argues, in fact, that the accuser judge cannot be the judge in the matter, because that is in the teeth of the principles of a fair trial, and the judgment itself comes to be vitiated by a conflict of interest. So the judge that is hurt by the sentiment that is expressed by an alleged contemner cannot be the one trying the matter. The judgment was also vitiated on this count. The third argument is that a lot of legal standards that were applied in Advocate Prashant Bhushan's matter to determine whether criminal contempt was made out or not were illegal and unconstitutional. And a lot of the charges were, in fact, the professor argues, quote unquote, void for vagueness for grounds that are, for principles that are enshrined in the case of Granite versus City of Rockford, 1972 Supreme Court. And the conclusion appears to be that the world has now moved away from the original test, which was the bad tendency test, which was excessively broad and slightly vague, which was subsequently also ruled in Brandenburg versus Ohio, which is 1969 Supreme Court, which is the year, 69 is the year. And the world moved away from the bad.
1 year after Justice Matthews' judgment,
Yes.
I think, the following.
Yes.
That's why he didn't refer to it. Otherwise, he would not have missed it. He would not have missed it.
Yes. Correct.
Even if it was 1 day before his judgment, he would not have missed it.
He would have got it. So the world moved away from the bad tendency test into what the professor's already mentioned, which is the imminent lawless action test. And perhaps if those slightly saner principles had been applied, the outcome of the case might have been very different. From the talk today, perhaps our key takeaways are that this confusion between defamation and contempt has extremely serious consequences. And perhaps secondly, there is also an argument to be made for the judicial system and the adjudicatory process also making space for and recognizing and respecting unwritten conventions of judicial interpretation, which the professors already discussed. It was such an incredible pleasure having you, Professor. In fact, after reading your article personally, it had been one of my tick lists to attend a speech by you, and this was just the prime opportunity to do it. Let me just go on to thanking all the organizers of the event. May I commence by thanking Professor Gopal for sparing the time and addressing us on this incredibly relevant, especially for people within the legal community, an incredibly relevant topic of conversation. May I also thank Justice Kauza for being with us today and delivering the introductory remarks. I also thank the Executive Chairman, Dr. Justice Jayashankaran Nambiar, who could unfortunately not be with us today, but on account of personal difficulties. But I thank him nonetheless. The Executive Council of ILI, especially Unni sir and Parvati ma'am, thank you for organizing this event. My seniors and other dignitaries who have joined in us online, who are not a part of the Zoom link, but hopefully are watching us live on YouTube. The Kerala High Court Advocates Association, my colleagues who have all joined me online today, Anupama, Mita, Neenu, etc. And all other friends who have joined us online, thank you for joining us today. This has been an extremely productive session for me, and I know it has been for all of you as well. Thank you once again.
May I just take 1 second to say that it's been really a great honor to be in the presence of Justice Kauser, who I admire very much, and is a person I have a lot of respect for. So thank you, sir, for sparing your very valuable time. I know how valuable your time is to be with us throughout this session, and it's an honor for me to be able to speak in front of you.
Excellent talk. It is a pleasure to hear you, sir.
Thank you, sir. Thank you so much, sir. And also to Madam Parvati Menon for inviting me and giving me this opportunity, which I really enjoyed very much. And it's a wonderful topic. When she sent this topic to me, I said it's a great topic. Yes, very important topic. Mr. Unni.
Thank you, sir. Thank
Ms. Anupama, and of course, Advocate Pooja Menon for such a brilliant intervention where you've sort of made what I say appear much better than it really is. So thank you very much for your kind words.
I've only reiterated what you've mentioned in the article. Yeah. So I've borrowed it word by word.
I can see that you all of you will be brilliant lawyers and in court. So you've summarized everything so well. So it's been a great pleasure for me and a great honor. Thank you very much. Thank you very much. Very